fact that we ourselves have called for the parents' certificate, for the husband certificate. Now, if we were to leave them out, it would possibly be doing injustice. After that doesn't mean that we are at impunity to.
No, but then you could have taken that. See, at that point of time, state should have been bold enough to say, we have, if earlier we have committed mistake, we'll rectify that mistake. The only criteria left for us is now to go by the learned single judge. I mean, possibly it's something, a situation, a tricky situation for the government created by itself.
Submit this. I can. There is no two ways about what it was. I'm going one step further. That we have violated the learned single judge. But that is not what the appellants before your lordship today are agreeing. Now, if we were to assume
no, therefore the appellant said you can't take a departure. If you were earlier framing your policy in consideration and insisting and following the apex court judgment, subsequently could not have departed yourself from something in addition, something.
Not departed. That's what I'd like to tell you. If he has departed and completely ignored the learned single judge's order and taken departure, or then you would have to take only, if you were to follow only the learned single judge's order and not our what necessarily done is we exclude all women who are applied under 2A, 2B, 3A.
No, please tell us three things very specifically. There is no true opinion about 12/12/1986 being a policy.
It is still there.
It's still there.
Despite our academic state, there is a need.
All right. The notification for recruitment of these teachers was issued pursuant to the policy. Now, it is also settled that any change in the policy has to be done in a manner known to law, not given by the judicial intervention. Now, in the instant case, you seem to have adopted both the methods. One is without following the change of policy regulations. Secondly, following the judicial intervention. How do you justify this act? And then, if the justification does not find place in the law, what is the consequence of that?
It finds the justification when the learned single judge directed us to take the parent certificate. We have followed and taken the parent certificate.
No, correct. See, the point, that's why we are trying to narrow down the whole issue. Yes. A policy can be changed in the manner known to law, yes, not even by a judicial intervention. That's a settlement. This would amount to.
Only once clarification. The judiciary got the director to do something. And we can't then decide.
No, can that? No, all right. No, correct. Can that be done during the currency of the notification?
Yes, which is why the learned single judge reserved liberty for us to continue the recruitment in reserved liberty in accordance with law
and if it affects even a single candidate, yes, the whole procedure would be tainted.
Let us assume that we completely discard our own circular and strictly follow only the learned single judge's order. Then also, I come back, even then it will only be 451 because there is no.
That's why we said whether it's 451 or minus 450, yes, even one person is affected,
No, which is why if the lordship were to direct us now, and we are open. Insofar as those, of course, for that your lordship necessarily have to hear the contesting particular also the original interpretation of the merits. And if your lordship were to take a view that the learned single judge's order is wrong, because we are open to redo it because it is in accordance with our circular. But why in the peculiar facts of this case, the state chose not to file an appeal? Is that the recruitment process is already ongoing? The advocate general appearing before the learned single judge.
No, you must make your stand very clear whether you stand by your circular or by the order here. Merely because there's urgency, merely because you did not file an appeal, does it justify the action?
I have not deviated from the circular. If I have to deviate from the circular, I would have to discard everyone's income certificate, all married women's income certificates along with their husband. So I have not departed. I have taken the husband certificate.
brother pointed out, Mr. Vikram, would have come before the court with a clear stand. See, there may be something you feel that now there's extreme urgency, etc., etc. But all this cannot permit us, as it is rightly pointed out, by number would be immaterial, even if one is subjected to discrimination or subjected to case where the constitutional principle is not followed. One, even one, that will not permit us to say that okay, there is some sufferer, and but then against him the urgency is to appoint 400.
It's small number. The intention of my having stated that is 450 is a sizable number, and as the Lordship rightly pointed out, one or two also is a sizable number. Even one person cannot increase. The purpose of me making that statement was that in the larger interest of the state, 12,900 remain unaffected. That was my purpose. 450 are affected. There is no doubt. It is. And at 450, I'm not saying for a moment it's a small number. But as the Lordship rightly pointed out, one also is a sizable number. 12,900 are unaffected. That was the purpose.
Mr. Vikram, subject to hearing other side, even assuming that this is a case of 415 affected and where there is 12,000 and odd waiting for the appointment who were selected. But merely because 1,200 and odd are waiting, we can't permit some injustice if caused to 451 who were initially, or even one who was initially properly selected, but in the second course or second exercise is kept away out of consideration. How? No, therefore, if the state wants to do it, it will again for the state to completely redoing of the exercise. That may take some time. That may then lead to a situation that may the earlier exercise becomes unfruitful or useless at the most. We will have to do that.
The entire exercise will become rendered useless. What I'm trying to say, that even assuming that this honorable court would satisfy the learned single judge's order, or to uphold the learned single judge, both ways, the fact of the matter is 12,900 will remain unaffected. Now, because in light of that, and after taking the opinion of the learned advocate, that the state took a decision to proceed in this half and half manner. Now, by proceeding in this half and half manner, again I reacted, 451 are affected, 12,900 are unaffected. Now, I only ask myself this question: would it be required to undertake the entire process when out of 15,000, 12,900 we have legitimately recruited, and for which nobody has, in fact, the appellants nor the writ petitions.
All right, if that is half and half approach is taken,
Yes.
and assuming for argument's sake that half of the process is held to be not valid, not sustainable, then if that is to be redone in the manner you had issued notification, how do you address the issue with regard to the other aspect of seniority and other things was being mentioned?
That was where the logic. We can come out with a suitable manner, or the logic of the directors to do something. We'll certainly work it. Seniority will be an issue. Yes. Yes, sir. What are the instructions and submitting? The seniority can be finalized after everything.
If 16,000 candidates have been done as per the notification as per 1986.
Yes.
Just a moment, just.
Yes.
Examination on minutes of the author of the not even the voluntary. So, the basic question is, the order of the minutes will be get to go for one of jurisdiction on 2 counts. First of the submission on petitioners come before this court with the principal prayer to quash this elections. I point out from the provisional selection. Therefore, it was a pure and simple service matter concerning recruitment to a civil service of the state. Therefore, learned single gets jurisdiction stood ousted by virtue of para 99 of Judgment Supreme Court in Tamil Nadu. That is the first aspect of the jurisdiction. Second thing of the jurisdiction. The next single judge did not have service roster at all. Either to, I do not want to use any, because any word I use, it can be treated as creating contempt. It was wrongly classified as GMCC to enable a general miscellaneous roster to get the jurisdiction. Whoever has done it is in contempt of the roster issued by honorable people. I have a larger than judgment of this court says if a judgment is called by a single judge, which falls outside the roster, on that ground alone it has to go without any fear being shut down minutes.
We can avoid that. This
Because-
submission we can avoid.
We have
No, let us say a question. We'll pass on it. Let's not have any comments on that.
yes.
I think we'll have to pass on. Sorry.
The question is-
Jurisdiction, you're right. At the first point, you're right.
Where the
We will go with the relief, we'll go with the pleadings. The rest, the second ground, I think will not permit. Please.
First point, yes, as I in agreement with brother.
We will avoid consciously, please.
Has examined identical issue. A bench of 5 judges have been constituted to go into that issue. It has been gone into. And it cannot be left to the discretion of the judge whether to follow a roster or not. Then it will be suicidal for rule of law. We will not, I can say, venture to go in that issue. Your first submission, okay. We appreciate that this probably could have been a first hurdle for the learned single judge to entertain petition on this count alone. When the I have faith. The compilation of document is all compilation of government documents. That is on 7/8/2023. Allotting the same 31st for that company. Okay, that is holding right. Only case, document number 5 is that case as people. Then the recruitment group. It's at the 36, the rule is in English from page 37. These rules, the rule one that states that these rules may be called Karnataka Education Department Services, Department of Public Instruction Recruitment System. It was for a civil service of the state. Then what's name? Of course, though it arises under another issue. This also may as a bearing, not on the particular jurisdiction. There is rule 7 at page 40.
Rule 7.
Rule 7, that is regarding reservation of posts. Reservation of posts shall be in accordance with the norms and extent provided by the Rule 9 of the Karnataka Civil Service General Recruitment. Extant orders of the government and extant laws, including the following: current orders of the state government in relating to reservation of posts for the persons belonging to scheduled caste, scheduled tribe, and other backward. This is requirement of a legislative rule made under section 3 and 8 of the Karnataka State Civil Services Act. You look at page 7, notice that these rules are made in exercise of the powers conferred by section 3 and section 8. The Karnataka State Civil Service. And the power under section 3 and section 8 of the Civil Service Act has been declared to be a legislative power. The power of the government to make rules for earlier traceable to Article 309 is now replaced by a legislative enactment Karnataka State Civil Service Act. And the power is conferred on the government to make these rules by virtue of sections 3 and 8 of that act. That power is legislative power. Then, my lord, document kindly take. Page 7, there is document number 7. Sorry, not that is in Kannada, but I will only read few sentences there. And try to the nature of creating digital relations is involved. Even this recruitment notification was not filed before this year. It's not part of the recruitment. In such a state of affairs, recruitment is needed. After all, recruitment rule and the recruitment notification, they are the foundational aspects to decide validity of any recruitment.
Now, last time when we asked, they pointed out it was produced in one of those petitions.
Yes, this is also, we are wrong. Not district.
Correct.
It also states.
Which
the
which page?
recruitment is for
Which-
this recruitment notification. Seven.
Yes.
Also said, recruitment is a state civil service. At page 48. First 3 lines. ಸಾರ್ವಜನಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ಸರ್ಕಾರಿ ಪ್ರಾಥಮಿಕ ಶಾಲೆಗಳಲ್ಲಿ ಖಾಲಿಯಿರುವ ಪದವೀಧರರ ಪ್ರಾಥಮಿಕ ಶಿಕ್ಷಣ 6ರಿಂದ 8ನೇ ತರಗತಿ ವೃಂದದ ಪ್ರೈಮರಿ ಸ್ಕೂಲ್ ಟೀಚರ್ ಇಲ್ಲಿ ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಡೆಲಿಗೇಟ್. Because there was no doubt that there cannot be any doubt that this recruitment is for a state civil service. If it is recruitment to a state civil service, if this is recruitment to a state civil service, then section 15(1) and section 28 are the administrative criminal act squarely apply. Section 51 and section 28. Powers and authority of state administrator.
Yes.
Say that otherwise expressly provided in this act, the administrative tribunal for a state shall exercise on and from the appointed date all the jurisdiction, power and authority exercisable immediately before the date by all courts except the Supreme Court in relation to one, recruitment and matters concerning recruitment to any civil service of state recruitment is civil service. And the Supreme Court can exercise this. Then kindly go to section 28. Exclusion of jurisdiction of courts, except the Supreme Court under Article 132 of the Constitution. Until the date from which any jurisdiction powers and authority becomes exercisable under the Act. By a tribunal in relation to recruitment and matters concerning recruitment to any service or post or service matters concerning members of any service or persons appointed to any service or post, no court except the Supreme Court shall have or be entitled to exercise any jurisdiction, powers and authority in relation to such recruitment or matters concerning such recruitment or such service. Therefore, this act totally worked. Then for the first time, full bench of the Andhra Pradesh High Court took a view that judgment of the Supreme Court in Sampath Kumar, which upheld the validity of the Administrative Tribunal Act, did not appreciate the fact that judicial review at the hands of the High Court is a basic feature of the Constitution. And that's wrong. It did not strike down either section 15 or section 28. It read down those sections without saying so in so many words, but created a small window of jurisdiction to the High Court. Now, what will I require to answer? Whether this is within that small window, this order of the nursing record, or whether it falls outside that window and hit a wall. It is not in that way. It is assumption of a jurisdiction which he lacked and statute permit. Now, I also find the compilation of judgment on 7/8/2023. Lord may take judgment number 2. Again, the power of judicial review. We have already did that. We have the power of judicial review. The jurisdiction of the High Court of Article 227 cannot fully be executed. It has been contended before that. The tribunal should not be allowed to adjudicate upon matters.
61. Eight letters, single very
Sir, it's not that the learned single judge was not alive or was made alive to this. The learned single judge also refers to that L. Chandra Kumar judgment. After reading this, I will take my notes to the relevant paragraph of Rangaraj and direct my notes to examine whether it fell outside the Chandra Kumar and the test of Rangaraj.
No, there is no dispute in our mind with regard to the jurisdiction of this court versus the jurisdiction conferred on the tribunal under the Act. No dispute on that. Para 8 of the impugned order may kindly be seen. Yes, that can be pointed out. Yes, that is sufficient.
Let me take para 99 or 70. Then I want to pay the position to apply the test of proportionality to see that whether
or it was not. Para 99. This bureaucratic reasoning adopted by us. We hold that clause 2B of Article 323A and 3 and clause 3D of Article 322 3B. To the extent they exclude the jurisdiction of the High Court and Supreme Court under Article 226 to